G'day, my name's Peter Coco. I'm the CEO and founder of Vleppo. Today I'm joined by Chris Sloan from Baker Donaldson and Jesper Nielsen from Focus Avocado in Denmark. The purpose of this discussion is to explore the applicability of NFTs from a legal enforceability perspective, particularly in relation to their use within Vleppo's contract management system. And a showcase that we recently held with Toggle, who are a non-fungible token platform provider. So I might just throw it to Jesper and Chris. Chris, if you can go first and just give us a bit of background to yourself.
Sure. So I lead the emerging companies team and the blockchain and cryptocurrency group at Baker Donaldson. We are a law firm based in the U.S. with 20-something offices, mostly in the Southeast, but we represent companies all over the U.S. and also cross-border companies doing business here in the U.S. And obviously, this is an area of the law that we follow very closely.
Fantastic. And Jesper, can you just give us a bit of background to yourself?
Yes, I'm also leading a smaller team, I guess, of focusing on new technologies, legal aspects of new technologies at Focus Avocado. And I also have a theoretical background. I wrote a PhD on some of the topics, not particularly on blockchain, but on how the legal systems are fit to adapt to new technology and digital technologies. So that's my main area of interest. That's the brief version.
Fantastic. And so I guess with the explosion of NFTs over the last 12 months, if we just sort of ignore the last couple of weeks, obviously, popularity within the NFT space has been enormous. And obviously, as part of that, a lot of questions have arisen along the way around legal enforceability of the NFTs themselves. I mean, we had the case recently with Seth Green and the Bored Ape, which was very interesting. I guess, Chris, I wanted to just get your thoughts around some of the challenges on NFT rights enforceability within the US, some of the pitfalls and problems and any sort of rules that we can sort of follow along as a guideline.
Sure. I mean, in general, when it comes to contracts, the U.S. is a very permissive legal regime, meaning that as long as you meet the elements of a contract, then you have a lot of freedom to contract with another party on almost any subject matter and via almost any medium, particularly as it applies to NFTs and contracts that are documented via NFTs, both at the federal level and in just about every state now. There is a law that explicitly acknowledges that electronic contracts are enforceable. So as long as you have a contract structure within an NFT that meets the general requirements, that there's offer and acceptance and some consideration, and that you can establish that the parties to the contract had the legal capacity to sign it, then there's no reason why they wouldn't be enforceable. The caveat, and I'm sure Jesper would have a lot to say about this given his PhD topic, is anytime you're talking about the law related to blockchain-based technologies in the US and frankly most other jurisdictions around the world, it's evolving rapidly. It's still very new, and we saw this same thing happen when the internet became more widely accepted as a tool that could be used in business. It was a new technology that collided with existing legal regimes in a bunch of new ways that no one ever would have expected at the time those laws were made. And it just takes a while for the courts and the regulators to catch up. And so we're seeing that happen now with blockchain and NFTs. So, some of the stuff we talk about today might be entirely different a year from now. Although when it comes to the enforceability of contracts, I'm not sure we're going to see a lot of change in that area.
Fantastic, thanks for that. Yes, but do you want to provide some context around any of the differences from an EU perspective and any insights that you can contribute there?
Yes, so I think the starting point is the same actually, and I base that not my PhD, but a good friend of mine wrote a PhD he turned in last year on how suitable Danish contract law is for smart contracts in a future with smart contracts, and the conclusion was, unsurprisingly, that we have no, as a general rule, we have no form requirements, and digital contracts and blockchain contracts would be as valid as a normal paper contract. So that's the starting point. But I think the difference between US and EU is in the many exceptions to that general rule. Namely, you have different kind of contracts with a lot of regulation and legislative requirements, for example, for consumer contracts or final contracts, where things get more complex. Both the validity of the contracts, form requirements, and enforcement might be more or less complex depending on what specific sector and type of contract you're looking at. So I think the where the US, when it is more lax when it comes to regulation, EU is in the other end of the scale and pushes out a lot of regulation, and that means I think there are more legislative stumbling blocks in the EU than in the US when it comes to this kind of digital contracts.
Excellent. So, in light of that, so I guess, and that's one of the reasons why I'm glad both of you could join, because it gives us both, or gives us a perspective of both ends of the spectrum, the more permissible US side and the fun and games that we enjoy here in the EU. So, I guess where I wanted to go with this next stage of the conversation was around some of the contractual enforceability issues with smart contracts specifically. So coming to your point earlier on, Chris, that there's really 5 elements to a contract being enforceable. There's offer, there's acceptance, consideration, the intention for parties to enter into a binding legal agreement, and then the 5th one being capacity. Smart contracts obviously manage to execute on the first 3, offer, acceptance, consideration, pretty simply. That's not an issue. Things get a little bit weird though when it gets to capacity and an intention to create legal relations, because, and my understanding, please correct me, my understanding is that those 2 areas are far more qualitative, which makes it highly problematic potentially for machine executable contracts to recognise and accommodate that. Do you have any sort of thoughts on that? Am I oversimplifying it, or?
No, I mean, well, I'll start off with this. I mean, I think the term smart contract is kind of an unfortunate choice of terms to use to describe what a smart contract is, because a smart contract in its purest form isn't necessarily the same thing as a contract for legal purposes. It's really just a set of sort of if-then kind of instructions that happen automatically once the conditions have been satisfied, and they're useful because it doesn't require any human intervention to cause those things to happen, as long as those conditions are things that the contract itself can objectively verify have happened. Contrast that with but it's not necessarily the same thing as a contract for legal purposes. So there's a bit of a terminology issue here, because a smart contract and a contract for legal purposes, if you drew a Venn diagram, they would overlap, but they're not one and the same thing. And so, I do think that a smart contract in some circumstances absolutely can be the same as a legal contract. I don't know that it's necessarily the case that you wouldn't be able to ascertain the party's intent to enter into a legal contract. It all depends on the terms of the contract and how the parties have the opportunity to accept or not accept the terms. But I certainly agree with you that offer, acceptance, consideration are sort of obvious, and in the US in particular, consideration is not something that the courts will typically scrutinize anyway. They typically assume that the consideration is there if the parties went through the process to enter into a contract. But it all depends on the terms and the the external factors around what leads into it. But I do think you can design a contract process that involves a smart contract where those things are easy to verify.
And Jesper, do you have any thoughts you'd like to add to that from an EU perspective, or any perspective for that matter?
Yeah, on the concept of smart contracts, so we have no actual legal definition of it yet, but we are actually getting close. We have EU regulation on crypto assets, so there we have some legal terminology beginning to see the light of day. And then in the UK, we are no longer part of the EU. Last year they published a law commission report, a 200-page law commission report, where they under the general term smart legal contract define 3 different categories of legal contracts, and natural language contract, automated performance, hybrid contract, and solely code contract. And I think that terminology is probably where we are going and what is needed for us to distinguish between, because many of the hardcore contract law issues are for the solely code contracts. Those are the most problematic, but when you can combine it with some more natural language contract, for example, a hybrid contract, or I think you call it a recording contract, if I understand correctly, becomes easier to fit it into the legal system as we know it today and the rules we have today, I think. But not there yet. But it's just the problem starts already with the terminology. I think that's my point.
Yeah, and I think that's where Vleppo. So we've been at this now for 4 years, and you're right, Chris. It's like where you start a year ago to where you are a year later. It's vastly different. So in a lot of ways, we've seen the evolution in this space over that 4-year period. And I guess our perspective on this was, okay, are smart contracts legally enforceable? There's a grey area. There's a grey area there. Some of them could be made to do that. A lot of them probably can't. There's that sort of real uncertainty in that space, and the amount of time, effort, and energy required to get a smart contract to the point where you go, yes, that's definitively contractually enforceable in a legal court. There's a balancing act of how much effort has to go into to bridge that gap. And I guess that's where, coming back to your point, Jesper, about a Ricardian contract, and that's what drove our direction was, can we take a smart contract or an instrument like an NFT, for example, can we anchor that into a Ricardian contract, which is effectively the hybrid between a standard natural contract and a smart contract as well, and effectively merge the two together to give that contractual enforceability to an NFT, which was part of the TOCL showcase that we recently did a couple of days ago. And from our perspective, and from where we sit, when we take the NFT, we take the NFT ID, which is the underlying asset. We put that into the Ricardian smart contract, such that when you see the blockchain record, you see the contract itself, but you also see verbatim the NFT ID, which effectively links these two things together. You've got the benefit of both worlds of the natural language, which deals with elements 4 and 5 being, intention to create legally binding agreement, and the ability or the capacity to do it with elements 1, 2, 3, which were already in there with the NFT in the first place. So effectively what Vleppo's doing in this regard is we are making any NFT legally enforceable under law. The second element of what we do is, because we use natural contracts, and we have a lot of flexibility around the language and the structure of that contract, the same as you would have in any contract management system, you can start to slice and dice the rights associated with an NFT in a far, far easier kind of way. So you may have a universe of rights on an NFT, and you may want to carve the rights off for, say, Botswana for whatever reason. That becomes a lot easier with the Ricardian smart contract structure, because you've got the ability to change the language around. Do you guys want to add to that at all, or shoot holes in us, or what's your take on that?
I mean, from my standpoint, it sort of gives you the best of both worlds, because adding the natural language into it really puts you into a contract structure that is a lot more like a traditional contract from a legal standpoint, but you still get the benefit of the immutability of it from the blockchain, which helps you with proof of what the contract was. It avoids things like version control problems, which are rare, but they do happen from time to time, and give you more certainty. But you still get the benefit of the things that you could do with the digital asset. So, I think that when you start designing a blockchain-based structure that incorporates natural contract language, it's a very useful tool.
Yes, so you got any thoughts on that?
Just that I think that the hybrid, or the approach you describe, at least it gives the flexibility to solve some of the contract formation issues. Depending on the use case, you might still have some of the enforceability issues left, depending on how self-executing the contract is. Because you would still, even though you have more flexibility in drafting the contract and perhaps also amending the contract, if you have a term in there which is usual, like force majeure, which is a term which are present in 90% of the contracts we made, how do you make that? How do you get that into code? And if for example, funds are going to be released in a given scenario, if there's a force majeure clause, how do you adapt that into code? I think that's still depending on the type of contract, of course. But if that's in there, that's I don't think the Ricardian, the hybrid contract in itself solves that problem with the self-executing contract.
No, exactly right. Well, the self-execution is always going to be the challenge there, and this is the piece, and I guess this is where our contract management system gets around it, because any action that takes place in our contract management system is solely dependent on mutual assent. So both parties need to agree to any event that takes place. So I might issue you a proposal, you accept the proposal, we now have a contract. If I want to vary that contract or do anything with it, I have to propose a change. Then you have to accept that proposed change in order for that to come into place. So we use, and I think, Chris, you went into this earlier on, that what we've done is we've used the blockchain frameworks to set rules that govern how these people can interact with each other. We have the benefits of the blockchain immutability, the portability of assets, et cetera, but at its core, this is still two parties on either side of the contract who have to mutually assent to how something takes place. And then to your point, Jesper, with regards to a force majeure event, one party just simply needs to raise a dispute to simply state, okay, I can't deliver because I've just had a plane fly into my office. And in that situation, the dispute is raised, and a mediator or a third party can make a determination. Has a force majeure event taken place? Yes, it has. Contract can be rescinded. So effectively, we have attempted to balance the smart contract aspects that are very, very attractive to businesses today, wrap it into a natural contract language process via the CMS, and then the contract management framework of mutual assent replicates effectively two human beings interacting with each other, which deals with the intention to create legal relations. It also deals with the whole principle of capacity to execute. The fact we can do escrow, et cetera, also that's your consideration, offer, acceptance, so on and so forth. So from that perspective, the framework itself is extremely robust in that regard, and it's got enough flexibility to navigate or move away from the machine executable issues that you're going to run into. The other point, and just conscious of time, but the other point I just wanted to quickly raise before we sign off is Vleppo's showcase the topper, where we took an NFT and then we embedded that into a Ricardian smart contract. Effectively, if that NFT has been structured in a way that it's not legally enforceable for whatever reason, by embedding that into a Ricardian contract, and having the natural language and having the ability for parties to interact with each other and mutually assent, does that not actually take that asset and technically transition or potentially transition that into being a legally enforceable agreement?
From my standpoint, the answer is probably yes. I mean, it's a little weird to talk about an NFT being enforceable because I don't really think of an NFT as anything more than just a representation of some sort of asset in most cases. Although it can certainly be other things, but the concept of, for example, embedding an NFT of a song into a Ricardian contract that defines a user's rights with respect to that song is a nice marriage of the benefits of an NFT in terms of being able to track the distribution of a digital asset like that with traditional contract law.
Fantastic. Jesper, any thoughts?
Yes, I agree.
Okay, fantastic. Well, guys, we'll finish it up there, and I just want to say thank you very much for your time to explore the whole that whole segment, and we'll talk to you guys soon. Thank you.